Today I'll be talking about Indigenous sovereignty mechanisms and the United Nations Declaration on the Rights of Indigenous Peoples, with special reference to the Australian situation. Sovereignty is a fraught but flexible term. For example, the OED offers multiple definitions of sovereignty, either supreme rule, power, or authority. That's kind of an absolutist approach to sovereignty, or the supreme governing power of a state or community, again focused on supremacy, or more modestly, the right of a state or community to govern itself. And that flexibility is inherent in how we use sovereignty in practice. In some sense, only the most powerful countries in the world are fully sovereign. After all, is New Zealand fully sovereign when New Zealand really has to make policy with an eye towards what Australia does? It doesn't really have full policy autonomy. Similarly, a state like New South Wales is not sovereign, but it is in many respects self-governing. So sovereignty is much more flexible than absolutists would have one think. Intrinsically, the very idea of Indigenous sovereignty does not mean the creation of parallel state institutions, since in that case it wouldn't be Indigenous sovereignty, it would be unqualified sovereignty, which is to say that if an Indigenous nation in Australia became sovereign, it would no longer be an Indigenous nation, it would now just be a nation. The usual focus of political demands for Indigenous sovereignty is that Indigenous peoples should exercise some degree of self-government within a larger national community. The demand is rarely for full political independence. In Australia, the 2017 Uluru Statement from the Heart exemplifies this ambiguity. It claims that the sovereignty of First Nations, quote, has never been ceded or extinguished and coexists with the sovereignty of the Crown. So that claim implies that there are multiple, probably around 1,000 or so nations in Australia that have full sovereignty on the level of the sovereignty of the Australian state. On the other hand, that claim itself is actually inconsistent with the Uluru Statement's call for, quote, the establishment of a, singular, First Nations voice enshrined in the Constitution. Since after all, if there are 1,000 or so First Nations in Australia, there should be 1,000 or so voices. That is, it is the idea that there are many nations in Australia is at odds with the idea that there should be one voice for those many nations. After all, in a proposed voice of, say, 9 representatives, it's inconceivable that even a tiny fraction of the Indigenous nations in Australia would have even any kind of direct access to that First Nations voice. Much more consistent with the claim of continuing First Nations sovereignty on the Australian continent is the Uluru Statement's second but much less well-publicized demand. Quote, and I'm quoting here from the Uluru Statement from the Heart, we seek a Makarrata Commission to supervise a process of agreement-making between governments and First Nations, and truth-telling about our history. Now notice there are 2 different classes of parties here, between governments, not the government, but multiple governments, the Australian government, state and territory governments, perhaps local governments, and not one First Nation, but many First Nations. And this demand of the Uluru Statement is really much more consonant with international conceptualizations of First Nations or Indigenous sovereignty than is the demand for a First Nations voice. Now, about that First Nations voice, for good or for bad, support it or don't support it, the simple fact is that in 2023, the voice referendum was comprehensively rejected. It was rejected by a vote margin of 60% to 40%. It was rejected in every state in Australia. Only the territory of the Australian Capital Territory voted in favor. Even the Northern Territory, with a very large Indigenous minority, but very large, on the order of 40%, still voted against the Indigenous, the First Nations voice. What's more, it's very clear that the relatively poorest parts of Australia voted overwhelmingly against the voice, while the places that voted in favor of the voice were the rich centers of the capital cities. So you see not even Sydney, but central Sydney, the inner east and inner west, voted for the voice. In Melbourne, central Melbourne, north central Melbourne voted for the voice. In Tasmania, only Hobart, right? The ACT. These are, in Perth, again, only the very richest parts of Perth. So again, whether you're pro-voice or anti-voice, the simple political fact is that the agitation in favor of the voice was not a widespread consensus among Australians. It was a narrow urban elite focus on the voice, which may or may not have had the support of a majority of Indigenous Australians. That remains unknown. Part of the problem with the voice, and I think the reason it was not more politically successful, come down to a few points about it. First, it was not proposed that the voice should be democratically constituted. That is, under the voice proposals, now not in the legislation itself, but under the voice models proposed by the activists for the voice, whose own models presumably would have been taken up by the government. After all, the government put this to a referendum on behalf of advocates for the voice. The advocates for the voice did not want a democratically constituted voice. They did not want to allow Indigenous Australians to vote for their own representatives. Now, I think that's a real challenge in the 21st century to say there should be a voice to Parliament, but it shouldn't be elected. It should instead consist of relatively elite Aboriginal Australians, mostly either in Canberra or who are politically connected with the Canberra capital bubble. That was not a recipe for broad acceptance. Further, there were scare campaigns against the voice on the basis that the powers of the voice were not explicitly enumerated, on the basis that the voice would not just advise Parliament, but also the executive government, that is the Prime Minister and the Cabinet, that the voice would be subject to Parliament. This was something that advocates for the voice, advocates for Indigenous sovereignty were upset about, that the voice would be subject to Parliament making rules about it, which is to say that any future Parliament could have eviscerated the voice, could have actually disbanded the voice and left it an empty shell. That's something that didn't sit well with people on the other side of the debate who wanted more robust Aboriginal sovereignty or Indigenous sovereignty. And the voice very explicitly did not recognize Aboriginal and Torres Strait Islander nationhood. The text of the voice resolution didn't say First Nations of Australia, it said First Peoples of Australia. So on both sides, both people who wanted a more robust endorsement of Indigenous sovereignty and people who were concerned about the operation of the voice was not warmly simply did not build a consensus around Australia, and thus we see this map of very widespread rejection of the voice, except among Australia's ultra-elite. Now, the voice debate largely ignored, I think to its detriment, the 2007 United Nations Declaration on the Rights of Indigenous Peoples. The United Nations Declaration was thought out over a period of years by some of the top Indigenous scholars and Indigenous rights activists in the world, including from Australia, who negotiated among themselves and with governments to arrive at a consensus best practice document. Essentially, this declaration is a best practice document for how Indigenous peoples should be allowed self-government around the world. The United Nations Declaration was hardly mentioned in Australia's voice debate, and many of the key principles of the United Nations Declaration were simply ignored in the voice debate in Australia. The UN Declaration can best be thought of as a guide to international best practice in Indigenous governance. So, for example, on education, Article 14 of the UN Declaration says Indigenous peoples have the right to establish and control their educational systems and institutions, providing education in their own languages. Now, this simply is barely done in Australia. There are a few schools in very remote areas in Western Australia that do some education in Indigenous languages, but very little. As far as I'm aware, there's no school in all of Australia that does Indigenous medium education, that is, teaches students in their own Indigenous languages. Now, you can go to a French school in Australia and learn in French, but you can't go to a school in Australia that teaches you in an actual Indigenous language in Australia. That's a shame. That's not something that was a matter of issue in the Voice debate. Indigenous education is something that that Indigenous peoples around the world have really fought for. It simply wasn't considered in the Australian debate. Self-representation. So Indigenous peoples have the right to participate in decision-making in matters which would affect their rights through representative chosen by themselves. Now, you'll see the qualification here, in accordance with their own procedures. That is a political waffle that is added, and I suspect was added by the non-democratic countries of the world, which is to say that all actually existing Indigenous consultative bodies and sovereignty mechanisms, every single one of which I'm aware, follows democratic procedures. This provision in the UN Declaration would allow non-democratic procedures, that is, in accordance with their own procedures. But I think that's there because if it had said in accordance with democratic procedures, China would have vetoed the declaration, or not vetoed, they didn't have the power to veto, but China would have lobbied against, many non-democratic countries would have lobbied against it. Now, Australia was in line with this provision, although it's not clear that the First Nations voice or the First Peoples voice to Parliament actually followed traditional Aboriginal custom. Regardless, this principle, I think, leaves out the fact, intentionally leaves out the fact that actual Indigenous sovereignty mechanisms everywhere in the world are democratic. Okay, back to things covered by Indigenous governance mechanisms. Economic development. Indigenous peoples have the right to maintain and develop their own political, economic, and social systems, secure in the means of their own means of sustenance, subsistence, and subsistence. I think that word is actually wrong there. And development. Sorry, subsistence and development. I have the wrong word in my mind. Now, this is done in Australia. There are Aboriginal land councils, local Aboriginal land councils that do manage economic development, but generally not in a very well-developed way. The only Aboriginal governance mechanism in Australia that really is actively involved in managing Aboriginal affairs for Aboriginal people is the Torres Strait Islander Association, and we'll talk about that in a few minutes. Administration of health and housing programs. Again, in Australia, there are often Indigenous representatives on health and housing bodies, but health and housing are not provided by Indigenous organizations, or if they are, the Indigenous organization tends to be advisory rather than actually providing the services. Certainly in Australia, Indigenous peoples throughout Australia are not taxed and don't have authority over the spending of their own funds in a way that in many other countries, Indigenous peoples and tribes and nations do have that authority. Custodianship of land and waters. Again, this is something that in Australia is possible through mechanisms like Aboriginal land councils, but was not envisaged for the Voice. That is, the Voice was not envisaged to provide education, to provide economic development, to administer health and housing programs. I think a voice along those lines would have been relatively popular. Instead, the Voice was to advise Parliament on what Parliament was going to do. That's not quite the same thing. And finally, I'd like to focus on the reason Australia, Canada, New Zealand, and the United States voted against the United Nations Declaration on the Rights of Indigenous Peoples. In fact, some of these, in particular Canada, New Zealand, and the U.S., have very advanced mechanisms of Indigenous sovereignty. But as countries that host Indigenous peoples that are also rule of law countries, they were wary of this principle of the right to redress, by means that can include restitution or just and fair compensation for lands, territories, and resources traditionally owned or occupied. Now, this would have meant that in all four of these countries, the entire country had been traditionally owned or occupied by Indigenous peoples, and that land had been confiscated, taken, occupied, used, or damaged without their free, prior, and informed consent. So, while on the one hand it may be fair to expect that Australia would compensate the descendants of the people who lived in Australia before 1788 for the use of the entire continent, I think that most people will realize that's politically unrealistic, that it was never likely to happen. Now, on the other hand, countries that voted for the United Nations declarations, places like Brazil, never intended to deliver on it. Whereas in our English-speaking democracies, there's an expectation that if they make a commitment to do something, that they will actually do it. So I think there's been a lot of virtue signaling, especially among Latin American and other post-colonial countries that have voted for these mechanisms, have been loud about Indigenous rights, have done very little to actually deliver on them in the way that the main English-speaking countries have. Now, supporters of the voice might be surprised by a provision that many First Nations around the world support, which is the idea of First Nations citizenship. In Australia, again, the voice would not have had the right to determine membership as Indigenous Australians. That is, it wasn't clear who would get to vote for the voice and how Indigenous you had to be to vote for the voice. In other countries, in order to have participation in self-government, you have to have, in effect, a citizenship or a membership. That is, Indigenous peoples have the right to determine their own membership in accordance with their customs and traditions. What that means is that people can't just claim indigeneity. They have to be accepted as Indigenous by the Indigenous group. Now, Australia has a nominal three-part test for indigeneity, that people have to be descended from Indigenous Australians, that they have to embrace their Indigenous identity, and they have to be recognized by the community. But in fact, that three-part test is not used in practice. In practice in Australia, people simply have to self-identify as Indigenous. That may be right or wrong, but internationally, one of the foundations of Indigenous sovereignty is control over membership. Just as a country decides who can immigrate to the country or be a citizen of the country, Indigenous nations overseas decide who will be recognized as a member of their nation. It is literally a nation. To illustrate the difference, in 2021, 2 local Aboriginal land councils in New South Wales complained to the New South Wales Corruption Commission, the Independent Commission Against Corruption, that the University of Sydney was allowing students and staff to self-identify as Indigenous. In 2022, the university promised that it would change this, that it would include as Indigenous for purposes of scholarships and jobs only students and staff who were recognized by a local Aboriginal land council or similar body as being members, as being Indigenous. This move was widely condemned by the existing Indigenous students and staff at the University of Sydney who had self-identified as Indigenous. That is to say, actual Aboriginal nations operating through their representative organizations that are democratically constituted and legally represented by the state of New South Wales were complaining that the university was letting non-recognized Indigenous people take jobs and student scholarships that were supposed to be reserved for Indigenous people. If I can quote from the CEO of the Darkinjung local Aboriginal Land Council, quote, "Issues with Aboriginal identity have continued to grow as people are self-identifying to access significant benefits. These are intended for legitimate Aboriginal people who have experienced dispossession and disadvantage due to racism, not for people who have not experienced these and who have generally lived a life at advantage and wealth." So here we see the division within Aboriginal communities between, if you will, those living on land or on country and those living in urban environments who culturally identify as Indigenous, but who don't participate in specific First Nations. Now, this illustrates the challenge between talking about First Nations, which is now the preferred language in Australia, imported from Canada, and the lack of commitment on the part of elite Indigenous Australians, the lack of their commitment to the concept of a First Nation, that is a nation that maintains its own membership roles, has its own fiscal and legal authority. In the rest of the world, First Nation sovereignty mechanisms are in fact quite widespread. There's nothing odd about First Nations or Indigenous peoples having some form of sovereignty. So, for example, the United States recognized 326, quote, domestic dependent nations. These are Native American tribes and other Alaskan and Hawaii Indigenous groups. These domestic dependent nations have legal corporate identities. They have membership roles. They decide who is recognized as a member of their nation. If somebody marries into the nation, the marital partner can be accorded citizenship in the nation or might not be accorded citizenship in the nation, depending on the rules of that particular nation. Similarly, Canada recognizes 634 First Nations, Native Canadian tribes, and in 1999 created a majority Indigenous territory, Nunavut, where the territory government is, in effect, controlled by Inuit Indigenous natives of northern Canada. New Zealand has roughly 100 Maori iwi. Iwi is a equivalent of a tribe. I say roughly 100 because for different purposes there are different numbers. Some sub-iwi are counted for some purposes as iwi and for other purposes as groups within a larger iwi. And there's 7 designated Maori electorates where Maori New Zealanders can vote for their elected representatives who represent them in the New Zealand Parliament. India recognizes 705 scheduled tribes. There are 407 seats that are reserved for members of scheduled tribes. It's not a direct sovereignty mechanism the way United States, Canada, and New Zealand are. Norway, Sweden, and Finland all have Sami parliaments. Sami are the indigenous peoples of northern Scandinavia. And here again, those Sami parliaments determine their own membership rules, have control over their own budgets, manage their own affairs in a democratic way, representing their own community within the larger national communities of these 3 countries. These governance mechanisms do broadly conform to United Nations Declaration principles. Native American tribes and Canadian First Nations determine their own membership rules and rosters, run education and social service programs. Many even have their own armed police forces. These are not, like Aboriginal Rangers in Australia who are bush rangers who are mostly advisory, who don't have the powers of arrest, who don't have weapons. These are fully armed police and police cruisers with sidearms, handguns, with access to more heavy weapons if they need them. That is, if you're on a Native American tribe or on a Canadian First Nations land and you break a law, you're going to have an Indigenous law enforcement officer come and enforce the law against you. You can be arrested by an armed police person who is not representing the state or the federal government or the locality, but actually is the Navajo police or is the Mohawk police who are enforcing the law. New Zealand doesn't go quite that far, but there are now, this is very recent since 2022, 15 iwi Maori partnership boards that manage housing and health for Maori New Zealanders. This is a shift from a single nationwide Maori advisory board, and the shift was highly controversial. The shift was controversial for the same reasons this tension exists in Australia between a New Zealand national Maori elite that wanted to maintain national broadly Maori control over housing and health services, and local actual First Nations Indigenous bodies, the iwi in New Zealand, that wanted to have local control over their own iwi-centric housing and health bodies. So that tension between the idea of Indigenous people as an undifferentiated mass, the Indigenous people of a country, and the idea of Indigenous people as First Nations, plural, has been playing out in New Zealand and has been just extremely controversial within the country. There are people on both sides of this debate. Scandinavian Sami parliaments maintain their own rota rolls, have their own budgets, manage their own affairs independently. Now, Australia does have some mechanisms for limited Indigenous self-government. The longest established is the Torres Strait Regional Authority. That's in the north of Queensland. It is an Indigenous body established in 1994 that manages local affairs in the Torres Strait. In 2008, there was an ACT, Aboriginal and Torres Strait Islander elected body created. That's in Canberra, in the Australian Capital Territory. It's an advisory body. In a way, it was the model for the Voice to Parliament, except that the ACT body is elected, and those elections are overseen by the Australian Election Commission in the same way that the Torres Strait Islander Regional Authority is elected, overseen by the Election Commission. In response to the failure of the national Indigenous voice, South Australia in 2023 went ahead with its own South Australia First Nations voice. Again, this is an elected representative body with democratic procedures for electing a voice to Parliament and an advisory voice to Parliament in South Australia. There are also local Aboriginal land councils. Now, that's the primary mechanism in New South Wales. There are 121 local Aboriginal land councils in New South Wales. There are also land councils or land council equivalents in the other states and in the Northern Territory. The land councils, again, are democratically constituted. Any Indigenous person within their boundaries can join and become a member. Many of the land councils, especially more rural areas, correspond to particular Indigenous nations, Aboriginal nations within Australia. Although in Sydney, there's been so much mixing and immigration over the years that Sydney has a metropolitan land council. And in general, even if you are not a member of a particular First Nation in Australia or Aboriginal people in Australia, even if you're not a member of that particular group, if you live in the area that is governed by that land council, you can still join and vote for that land council. And there are also Indigenous corporations and councils, mainly in remote areas in Northern Territory and especially in Western Australia. And in Western Australia, many local councils are so close to 100% Indigenous. That is, there's no one who's not a member of the local Indigenous community who served by that council, that in effect the council is governed by the Indigenous community itself. Now, note here that of these bodies, most are purely advisory. The only ones that are not advisory are the New South Wales and other Aboriginal land councils and corporations, but they have relatively limited budgets and limited authority. Note also the severe constraint that these bodies generally do not have full-time paid executive staff. The Torres Strait Regional Authority has one full-time chairperson, and other than that, everybody who works there is part-time. The South Australia First Nations Voice, for example, the payments for that are extremely low, a few $100s for the members. That is to say that these organizations can't be full-time, full-year bodies like the Australian Parliament or the New South Wales Parliament, where people earn a salary and have staff members to help with their staff work. In other words, these organizations do not have the capacity to engage in governance. They really only have the capacity to be advisory. The main challenge here is a lack of meaningful sovereignty. Advisory authority is not the same as sovereignty. The advisory mechanisms, like the proposed First Peoples Voice in Australia, acknowledge the sovereignty of the Parliament and of the colonial government while giving a small number of Indigenous individuals an advisory role within that government, and give a small number of Indigenous individuals frankly, well-paid jobs advising that government. On the other hand, sovereignty means actual responsibility for administering the funds and administering the responsibilities that come with government. I mean, sovereignty means self-government, not merely giving advice to someone else on how you might like to be governed. Lacking full-time salaried executives and representatives, that's just not possible in Australia. Australian organizations also generally lack key aspects of sovereign entities. For example, they may deliver educational courses under contract on behalf of governments, but they don't have control over their own educational curriculums. They may have some advisory authority and veto power over land use, but typically they don't own outright the land that are their traditional lands. This is very different from the U.S., where the Navajo reservation is the Navajo's land. I mean, that they can do what they want with. And if someone is going to build a gas station for motorists on that land, it's the Navajo authorities' right to decide who's going to get that contract, right? So the full sovereign control over land is Australian. It goes much farther than what Australian native title allows, at least at this point. And I think crucially, the one thing we most thoroughly associate with sovereignty is police power. Sovereignty means that you can arrest somebody. That is, it's the awesome majesty of the law that someone can literally come knock on my door and take my liberties away and arrest me here in Australia. That authority in Australia is invested in a democratically elected, accountable government. Well, none of these Aboriginal governance mechanisms in Australia have that kind of sovereign authority over individuals. They are advisory and representative organizations, but I want to stress, in Canada and the United States, if you live on Indigenous land, an Indigenous officer can come knock on your door, arrest you, and put you in an Indigenous prison if you've broken the law. That is real Indigenous sovereignty. Thanks, everyone, for listening. I hope you found this interesting. I know the material is highly controversial, and many people will disagree with things I've said. My goal here really is education and trying to put things in a perspective that many people who just hear about the debates and arguments going on may not really have thought of. I really do think that Indigenous sovereignty is not just a slogan. It is something that has an awesome, and I don't mean that in the sense of fantastic, I mean it in the sense of awe-inspiring, that somehow there's an awesome meaning to the very concept of sovereignty. It gives a people the dignity of governing themselves as a group. That's not something to be thrown around lightly. If we mean Indigenous sovereignty, we should be serious about, well, what it implies, and we should be very cognizant of the difference between, a word that sounds nice, First Nations as used in Australia, and a word that has actual meaning, First Nations as used in Canada. And I say that not to be disrespectful to Australian First Nations, but no Australian First Nation has sovereignty in the sense that Canadian First Nations do. And I think it's a pathway towards better social policy, better outcomes for Indigenous people, and greater self-respect and self-reliance on the part of Aboriginal and Torres Strait Islander Australians if they are allowed a pathway toward true Indigenous sovereignty.